and see what the camera is going to record. Look at the background. Look where your witness is going to be sitting. Look, to see if there's an Altoids box there or whatever. One of the things that we like to encourage our witnesses to do is not have a bunch of clutter in front of them. The clutter's over by the lawyers and all that. But I wanted to mention that too, because it is very helpful for you to see what the jury or whoever's going to see, and the videographers are used to doing that. Following up on what makes a good witness, this is kind of it has a different title, but I cover some of the things. What every witness wants and needs to know before the deposition. As basic as, what do I wear? If it's a police officer, do you want them to wear their uniform? Do you want them to wear an open shirt? If it is a truck driver, do you want him to wear his Detroit Tigers hat during the deposition? Do you want him to wear a Bubba t-shirt? These are things that if we don't tell the witness or make suggestions, I've been told, on what to wear, it could be surprise to all of us. And I think I told Dick we had a case in Muskogee, and we're not going to tell war stories, but before we're going to select the jury, and this guy shows up in a Hawaiian shirt, I promise. So we went to the Kmart there in Muskogee and bought a white shirt for him. But it was my fault because I didn't tell him. The other thing is how to act towards the other people in the room at the deposition. The videographer's going to be there. They'll be setting up. The court reporter's going to be there. I always tell them, introduce yourself, or I'll introduce you, but you don't need to engage in conversation with them. Don't be rude, but they're setting up and things like that. And because Dick Gann, if he's in the room, he's listening to what my guy's chit-chatting about, and may find some nuggets there. When do you want me before the deposition, and where do you want me to be? I know that is so basic, but you're going to find out that a lot of people saying, where do I need to be and when? Go ahead and tell them. This is a scary deal for the lawyers that we can control, but the witness may ask, what do I need to bring with me? Well, if you don't tell them, don't bring anything. They may bring a sack of records that they've kept, photographs that they think are important that you've never seen before. So I always want, and I think Dick and I've talked about this, I want to know in advance what they think they should bring, and I want complete veto power on whether they get to bring it or not. Not that I'm, way above them, but I'm looking out for the protection during the depo, but also we don't want to undermine our case.
And that goes for that. The classic case is the witness or the client who brings a stack of documents with them or in their briefcase, and the questioner will ask, what did you review in preparation for your deposition? Oh, I reviewed documents A, B, C, and D. Here they are. Next question, do you have them with you? Yeah, they're right here. Well, you've got to produce them in order for the other lawyer to review them. Well, you may want to make the decision as to whether or not you want that client to bring those documents with him. So,
the other thing is about documents, and Dick talked about that, is if you're going to go over documents with the witness. I mean, if you're going to use the deposition, obviously you want to go over them beforehand. The other thing that they were talking about, what every witness needs to know, is to be able to tell them it's all right not to agree with the other lawyer if you don't think it's right. During the course of exchange of communication, good lawyers like Dick Gann are very friendly. And you'll agree with me, gosh, Wednesday morning at 7:30, that's pretty early to start a CLE program, isn't it? And and gosh, that coffee was good, but as I was coming here today, I was driving down that street, and where that accident happened you were in, and I can see why you would ran that red light. Well, Dick's a good guy, And the witness is going to say, yeah, yeah, the coffee was cold or whatever, and it's early to start, but tell them they don't have to agree just because he says something as a question or a statement of fact. And a lot of people that aren't used to litigation and not used to being witnesses are really turned off at this because they want to be nice. They want to appear cooperating or cooperative. But again, it's okay not to agree just because someone says, wouldn't you agree, if it's not true. Another hurdle that a lot of people say is, witnesses say, well, I answered the question and then I wanted to explain more. Why wouldn't you let me? Okay? Now, hopefully that's after the deposition that question comes to you. But again, we're telling them, you have a particular role in this case. There are particular items of information that if the other side needs to find out from you, let them dig it out. You're not there to educate them. You're not there to persuade them. You're there only to answer their questions. But I've had more, and you will too, if you haven't already. I've had a lot of people say, I sure wish you would let me tell this and whatever. Okay, the other thing that, Dick, we talked about was to address some things about how we're going to conduct the deposition.
Yeah. And Buddy, before we get to that, one more item of preparation before we leave it, and I just thought about this. What you'll find, and this particularly goes to videotape depositions you intend to introduce at trial. It may be a physician, it may be some other expert, but judges and, more importantly, jurors are turned off. They're annoyed if you conduct an hour and a half video deposition. They're going to go to sleep, they're going to be bored, and they're going to stop listening. And if you're a trial court, you're going to become exasperated with the lawyer who put everybody through that because you're wasting the court's time. And that means that you plan your deposition and you hit your points and you streamline that video deposition to get the information you want and end it. And so that you hold the jury's attention, you make your points, and you go on. So I want to make that point.
Dick, one of the things that you had on the outline was, as we go into this, the conduct or conducting a deposition is kind of the format. We've touched upon some of those things, but one of them you said, depending on if you are taking or defending the deposition, what about, let's say you're taking the deposition, do you like to use closed-in questions, or do you like to open-ended, leading, tell it all, brother, type questions?
Well, I think it depends. If you are deposing an opposing party, as all of you know, you're allowed to lead the witness, and you can ask leading questions. On the other hand, if there's a possibility that you may need to read that deposition at trial, the witness who may absent himself or something, you've got to think about whether and be cognizant of whether the other lawyer objects to the form of your question as leading while you're conducting the deposition. So that if he does, and if you intend on using that deposition at trial, then you'd better revert to non-leading questions. That's a rule I go by.
Dick, you talked about objections. What is, I know in the materials that you've addressed that Oklahoma is somewhat restrictive as far as the speaking objections and the responses when you're defending. And do you have any thoughts on that as far as the deal where the lawyer is spending 2 minutes of the video time
Educating the witness?
phrasing their objection so that the witness understands that he's, about to be in some landmine areas?
Well, yes. All of you ought to familiarize yourself, and some of you older guys have probably memorized it by now, Local Rule CV 20.5, which says, in essence, that when you're at a deposition and you want to make an objection, the proper objection is object to the form, or when you're talking about a objection to a question, or if you're going to object to testimony, you're limited to objecting as non-responsive. You're in danger of waiving an objection if you engage in what we call speaking objections, or objections that are purposely designed by the lawyer to educate a witness as to what he ought to or ought not to say. They're frowned upon, and frankly, during the course of the deposition, if I encounter it, I'm going to remind the other lawyer that even if we're in a different county or a different jurisdiction, that we're to limit our objections, that speaking objections are improper, and after I give him the friendly warning, I'm going to make sure that my record is properly records the objectionable conduct by the other lawyer, and then I'm going to tell him we'll either call the magistrate, or if you're in federal court, or we'll call the judge if that's practicable in state court, and ask the judge to intervene. Or if once you have your improper conduct and you're confident in your record, then you can tell the other lawyer we're going to adjourn and I'm going to seek sanctions, because it's improper for you to educate a witness like this. Or even if it's not speaking objections and this sort of thing, if the other lawyer is oppressive or engaging in harassing type of action, it's proper to adjourn the deposition and seek sanctions and seek relief from the court, because it just doesn't play a role. It's not productive, and we all know we've all had experiences at it, and it's time to clean it up.
Dick, as far as time, we're kind of running down as on our time, but let me ask you a question. What do you usually recommend to your witness at the conclusion of the deposition when everybody asks their last questions, and I'm starting to put stuff in my briefcase, and the reporter says waiver sign?
Well, I want my clients to read the deposition and sign it. As all of you are aware, statutorily, witness has the prerogative to waive signature of a deposition. But I want my client or a witness to have a chance to read the deposition, to take out the errata sheet and make any changes to his testimony that he thinks may be appropriate. And you can do that. If you read the statute, you can do it. And of course, the original testimony will go into the record as well as the changes, but it gives that witness the extra chance to review his deposition. That's what I do. There's one of the things that I wanted to add in the conduct of a deposition. Learn to ask short, simple questions. Learn to ask questions in a manner that will button down a witness's testimony. And I wrote down an example here. For example, don't ask the question, you were not present, because when you think about it, if the witness answers yes or he answers no, it can be confusing later, and he can take an opposite position either way. I would rather ask, were you present? He's either going to say, yes, I was present, or no, I was not. So think about that when you're composing your questions. Limit your objections. Don't coach the witness. I would say this, that when you're in the course of a deposition and you need to object to the form, and if the other lawyer asks you for the grounds of your objection, give them to him. Don't simply say, oh no, I don't have to give them to you. Because if you read the rules, if you read the statute, if he's not given a chance to rehabilitate his question, you may have waived your objection. So think about that. Have your grounds in mind, and if he asks for them, give them to him. Another thing I do, Buddy Neal may have finished his examination of my client, and my client may have said a thing or two or three that needs clarification. Now, that's not true if Buddy has failed to ask all of the information, which Buddy Neal's not going to do, but if a lawyer fails to ask doesn't avail himself fully of the chance to depose my client, that's one thing. But if Buddy asks a question and my client gives an answer that I know is inconsistent with the documents or with the facts that Buddy can demonstrate later, I will write the question down and I will go back to my client and say, now, Mr. Client, in answer to Mr. Neal's questions, you said that it was dark outside, but the record reflects, doesn't it, that it was really light outside that day, because you don't want Buddy to stand up at trial and be able to impeach my client with the fact that it was actually daylight when the client at the deposition said it was dark. So take the initiative, cure the inconsistency